All rise.
My lords, my lady, could I turn now to HAY's cross-appeal on remedies and hopefully deal with that reasonably promptly?
Yes.
There are 6 points that we make. Firstly, the obvious point that remedies are within the discretion of the judge. Secondly, that in the present case, the judge's conclusion was specific to the facts of the case that had been before him, as he saw those facts to be. Thirdly, as a matter of discretion, he was fully entitled to formulate a remedy that fitted that particular case, and the declaration that he did make did precisely that. It took into account both the fact that the Foreign Secretary had already, prior to the hearing, decided that an application should be made on HAY's behalf to the 1267 Committee. It also reflected, or I should say the judge's decision was also reflected in the way in which the Al-Qaida order was thereafter to be applied to HAY, pending consideration of his case by the 1267 Committee. And details of that, perhaps for your note, are at paragraph 36 of our printed case in HAY. Mr. Hussain yesterday referred to the adjustments as minor, but in fact they included the removal of the reporting requirement relating to reporting how the state benefits paid to HAY and his family were used to ensure they were used for basic expenses. So that requirement was removed. And secondly, to the extent that there had been funds frozen in bank accounts at the time that the order was first applied to HAY, the effect of decisions taken was to release those funds. And so it remains the case that in respect of the state benefits which are paid to HAY, there is a requirement that they be used to meet basic expenses, but that is the only requirement. And in those circumstances, we say that the conclusion reached by the judge was one he was entitled to reach. The alternative, I presume, would be some form of mandatory order or quashing order directed to the Al-Qaida order itself. The difficulty with such an order would be simply that one could not formulate a quashing order that was specific to HAY given the terms of the Al-Qaida order itself. Again, it's back to the point that the domestic measure that applies the order to HAY is Article 3.1b. So if one simply quashed Article 3.1b, the consequence of that would not just be for HAY, it would be for all persons designated by the 1267 Committee, who of course were resident in the United Kingdom. So in all those circumstances, we say the conclusion that the judge reached in the circumstances of the case was a sensible, pragmatic conclusion. It's been reflected in decisions that have been taken subsequently as to the application of the licences and was well within his discretion. My lords, my lady, the final part of my submissions concerns the issues of special advocates and the Regulation of Investigatory Powers Act. Could I deal with this first by reference to our printed case in G's appeal at paragraph 92? The only extent to which these two matters are live issues is to the extent that the cause of action identified by the Court of Appeal properly exists. If there is any claim made in respect of a decision taken by the Treasury in the exercise of its functions under the order, that would be a claim governed by the provisions of the 2008 Act, including specific provision for requesting the appointment of a special advocate and a disapplication of Section 17 of the Regulation of Investigatory Powers Act in those proceedings. And so the only type of claim that is relevant is the sort of claim that the Court of Appeal identified. Clearly, our first submission in respect of these matters, therefore, is that that claim, as identified by the Court of Appeal, does not need to exist in order for the Al-Qaida order to be lawful. And so, on the basis of that submission, any issue as to special advocate systems or the application or disapplication of Section 17 is immaterial. The second point we make is this: even if one assumes that the cause of action identified by the Court of Appeal to challenge and review the merits of the 1267 Committee's decision, assumes that cause of action is necessary, any question of fairness as to a particular set of proceedings would be dealt with by the court on the circumstances of that case, having regard to the tools available to it. The short point is that the possibility that in one or other future cases there could be an issue as to fairness does not produce the result that the Al-Qaida order itself is ultra vires, particularly as the cause of action that the Court of Appeal identified and Mr. Singh contends for is, as he described it, effectively a claim for judicial review. It is not proceedings under the Al-Qaida order, and in those circumstances, any problem arising in connection with those proceedings is not such as to affect the legality or the vires of the Al-Qaida order itself. The third series of points that we would make are the points that we have set out in our printed case in the appeal of AK&M, where this matter was first raised. And the relevant parts of the printed case in AK&M, it's paragraphs 115 to 122 as regards special advocates, and paragraphs 123 to 142 in respect of the Section 17 point. My Lord, if it's acceptable to you, as to special advocates, I wasn't intending to say anything beyond what is in the printed case. The short point made in the printed case is that to the extent that the court thought that it was appropriate to appoint a special advocate, it already has the power to do so. What is in issue is simply the exercise of the power from case to case. There is no issue going to the legality of the Al-Qaida order itself. That essentially was the conclusion of the Court of Appeal. With regard to the Regulation of Investigatory Powers Act, could I make just a further couple of short points in addition to the matters set out in our printed case? Various scenarios are raised by AK&M and now G. The first is as to the fact that in the proceedings the Court of Appeal envisaged, it would not be possible to disclose material covered by Section 17 to a special advocate. That is the first point. Now we accept that that would be the consequence of Section 17. Section 17 has not been disapplied to the sort of cause of action the Court of Appeal envisaged. But the Court of Appeal specifically identified how this problem would be dealt with in order to maintain and ensure the fairness of the proceedings. In particular, in the Master of the Rolls judgment, it's paragraphs 74 to 76 and then 78. You may recall that in those paragraphs he identifies 4 classes of case, classes of situation where there might be a problem arising by reason of the presence of intercept material and the application of Section 17. Now, his 3rd and 4th classes of case are specifically premised on a situation in which a special advocate would not be permitted to see the intercept material, the Section 17 material.
Could you just remind us what they are? The 3rd class was wholly inculpatory material, and the 4th is part of one thing and part of another, isn't it?
Yes, I'm sorry.
So they both include exculpatory material.
The 3rd class is wholly inculpatory. The 4th class is some exculpatory, so any exculpatory. And the point he made in relation to the 4th class, and a point, a conclusion that he reached based on the submissions made by the Treasury to him on that occasion, was that effectively there may well be situations in either the 3rd or the 4th class of case where the existence of the prohibition in Section 17 required the Treasury to change the shape of its case, to withdraw matters, to cease to rely on matters, and ultimately, depending on the circumstances of the case, perhaps to cease to defend an application at all in order to ensure the fairness of the proceedings. In that case, the Treasury would act in the same way as a prosecutor would act in accordance with the Attorney General's guidelines. And so, overall, there are circumstances by which the court can ensure the fairness of the proceedings. In the situation of exculpatory material, if the judge wished to satisfy himself, for example, that appropriate concessions or appropriate admissions had been made, he could require the disclosure of that material to himself under Section 18.7. So all these matters enable fairness to be addressed from case to case, and there is no reason why the conclusion should be reached that the Al-Qaeda, or for that matter the terrorism order itself, as a whole, is unlawful. The second scenario concerns disclosure of Section 17 material to counsel for the Crown. On that, our primary submission is at paragraph 134 of the AK&M case. That is simply that suggested construction of Section 17 is incorrect. Section 17 is clearly designed to address 2 potential harms, 2 dangers. First, incursion into the privacy rights of those whose conversations are intercepted. Secondly, to remove the risk of harm to intercept capability in terms of protecting the national security capability of the United Kingdom. Now, neither of those harms would be visited, would come to pass in the event of disclosure of intercept material to counsel for the Crown for the purposes of conducting proceedings or advising on proceedings. And so it is an overreaching construction of Section 17. And for that reason, we say it is an incorrect construction of Section 17. But even if that submission is rejected and the appellant submission is regarded as correct, that itself would not advance the proposition that for that reason the terrorism order or the Al-Qaeda order was ultra vires. I mean, again, the resulting situation would be one in which perhaps specific material was not available to the Treasury to deploy in proceedings. And in those circumstances, the Treasury would be obliged to make sure that the case it did put forward fairly reflected the material available to it. And so it may be required to make concessions or to make admissions as appropriate. Once again, there are adequate mechanisms from case to case that can ensure fairness, and there is no logical link between those problems and the conclusion that either of the orders in their entirety was ultra vires. The next category of material was disclosure of intercept material from the Treasury. And on that point, we simply rely on the submissions contained in our printed case. Clearly, disclosure by one government agency to another would not be in respect of the purpose envisaged by Section 17. It would be simply in accordance with the normal day-to-day exercise of the Treasury's functions in ensuring the proper application, no greater than necessary, no less than necessary, of, for example, the Al-Qaida order or the terrorism order as appropriate. And finally, there is the question of disclosure to a judge and the fact that it is said that Section 18, subsection 9 of the Act does not apply to civil proceedings. Well, that's absolutely correct. It is framed in terms of criminal proceedings. But the power at Section 18, subsection 7, we say clearly is wide enough to permit a judge to see material in order, not so that he can rely on the substantive content of it for the purpose of reaching any decision, but simply so that he can satisfy himself, for example, that it's properly within the scope of the prohibition, or alternatively, that if a concession is to be made on the basis of the non-disclosure of that material, the concession is properly framed. That is a course of action which has been taken by courts in other cases. One example that we refer to in our printed case is Coles and Barracks, which was the decision of the Court of Appeal concerning proceedings before the Employment Tribunal. And in his judgment in that case, Lord Justice Munro specifically envisaged the possibility of such a hearing before a judge in order, if necessary, to ensure that even though there was material that was relevant but not disclosable, the proceedings overall had been fairly conducted. So for those reasons, we say that none of these points actually has any substance to it, but in any event, none of them requires the conclusion that either order as a whole is unlawful.
Well, what's the reasoning in relation to the Al-Qaida order? I mean, I know your primary reasoning is that the only decision which is relevant is the
yes.
decision that the person is designated. So there's nothing that a special advocate could do. But if you're wrong about that, as the Court of Appeal on one view thought, then Court of Appeal, the Master of Rolls, said in paragraph 120, this is a parallel situation, leave the problems to be sorted out case by case when they arise. But it doesn't work, does it? The special advocate couldn't be given access to the 1267 committee documents or reasoning.
To the extent that, actually, it would depend, because at the moment we're only talking about Section 17, and so in colloquial terms, intercept material.
Yes, yes, I
now,
see.
to the extent that there were 1267 committee documents that were not publicly disclosable, those could be disclosed to a special advocate. To the extent that there was intercept material, the means by which fairness of the particular proceedings would be ensured would be by, firstly, the Treasury properly assessing its case and, if necessary, making concessions or removing matters from the case to ensure that a misleading approach was not given, if necessary, with the assistance of the court under Section 18.7.
But in the end of the day, it's up to to the Committee of the Security Council to decide what material justifying its own decision should be released. Is that not right? I mean, there's no method, no means of compelling them to release anything at all.
In terms of public release, no, there is not. But in terms of as I said before, the adjournment, the United Kingdom is in substance a permanent member of the 1267 committee.
Of course, yes.
And so in terms of the availability in principle for disclosure in proceedings, that material is available to the Secretary of State. It may well be necessary for that very reason, in some cases, to request the appointment of a special advocate so that that material could be used in a secure environment. But that, of course, I accept is a point apart.
That would cover probably all the material that was confidential, that hadn't been released.
Indeed, yes. But and the question of public release is an issue apart. Yes. And this, we say, obviously coming back to Hay, was really the confusion that was, or one part of the confusion that was operating on the judge's mind. He, as it were, aligned what the Secretary of State could disclose to HAY and his lawyers with what the Secretary of State actually had. My Lords, those are my submissions on the fifth point. I've been reminded that I haven't actually. There's one further thing I should say in response to the question my Lord Walker asked yesterday afternoon. My Lord, you expressed concern as to the duration of the application of the sanctions. Could I just draw 2 points to your attention, which I hope at least assist in terms of providing information? Firstly, the Security Council resolutions themselves are resolutions that are regularly renewed. For your note, at paragraph 40 of Regulation 1822, the statement is made that the resolution is to be reconsidered within 18 months.
Paragraph what?
40, my Lord. That resolution was made in June 2008. The process of reconsideration is in fact presently underway with a view to adopting a replacement resolution before the end of this year, so within broadly the 18-month period. My Lord, the second point is that the Al-Qaida order itself at Article 17 contains a provision that expressly provides that in the circumstances that the Security Council resolution ceases to apply or is disapplied to any extent, to that extent the Al-Qaida order itself ceases to apply.
Well, that's unsurprising, is it?
Well, my Lord, it's not, but I simply make the point that the matters are linked together in that way. And, my Lord, in addition, of course, there are the matters I referred to this morning, the opportunities for application to the 1267 committee itself. And perhaps I could make this observation, that clearly the sanctions themselves were intended to be of a long-term duration. One can see that from the purpose being pursued by the Security Council itself. But they are always subject to the continuing need for the person concerned to meet the criteria for inclusion on the consolidated list. And to that extent, the basic situation before this court is really no different from the situation that was before the House of Lords in Al-Jeddah. To that, in that case, the power of detention on imperative grounds of security again arose, and the power to detain continued for so long as it was considered that the person concerned should be detained because he met the criteria for detention. And so the detention considered in Al-Jeddah was not in that sense temporary, it was indefinite, subject to the person concerned continuing to meet the criteria.
But it's fundamental, isn't it, that the purpose is, as the Master of the Rolls said, protective. The purpose is to stop the funding of terrorism. It isn't to punish individuals because their name is on a list. And one would have thought that once someone's name was on a list, once they were known to the security services of the state in which they were resident, that the chances of their continuing actively to raise funds and to fund terrorism would be fairly limited.
Well, with respect to that's a judgment on that. That is a point on which clearly different judgments could be made as to what was the effective means of continuing prevention. And clearly the judgment of the Security Council is such that to the extent that a person continues to meet the criteria it set out in its resolution, they should continue to be subject to the prohibitions it has specified.
Yeah, the Security Council is not exactly on the spot, is it?
Well,
it is very, very stretched lines of communication, isn't it, really?
Well, necessarily, the Security Council is assessing the position at a strategic level. And I would say that its conclusions as to what measures were required were none the worse for that. It saw the existence of a threat from a global terrorist network, saw that threat as being a long-term threat, and responded in a way that it considered appropriate to address that matter.
Just as there's no misunderstanding, paragraph 40 of the of 1822
Yes.
says decides to review the measures described in paragraph 1 above with a view to their possible further strengthening.
Yes.
In 18 months. So it's not a review, as it were, open-ended. At least it's not suggesting that it would be with a view to the thing being reduced or removed. So it's further strengthening that's being...
Yes, but in fact, the process of review is a process of review that starts with first principles and then works up in terms of the negotiation, the drafting of any possible further resolution. I do...
I would feel more comforted if it wasn't qualified to quite that extent. I mean, if it had said review in 18 months, full stop, then one would feel a little happier about it. But it's pointing in one direction on the wording as we find it.
Well, I fully accept that point, but all I can say is that the review itself is a review that, as I say, starts from the bottom and works its way up.
But realistically, these orders are going to run for a long time because there's not in most cases, going to be a terminus ad quem at which a court reaches the decision, guilty or not guilty.
Yes, well, inevitably, yes, they will run in particular cases for so long as the person remains on the consolidated list, and clearly, what one cannot but accept that these are meant to be serious and severe measures, but they are intended to, as I said earlier, to withdraw and remove the possibility of access to funds, safe on humanitarian grounds, to persons who it is believed would use those funds either to facilitate or to support or commit acts of terrorism. One is addressing a particularly severe social and political problem, and somewhere a balance needs to be struck.
Supposing somebody were prosecuted and acquitted, he wouldn't come off the list automatically.
No, in the context of the Al-Qaida order, my lord. Yes. No, he would not.
No,
because again, the question of the merits of whether somebody should remain on the list is a question for the 1267 committee.
Well, G went on the list after he'd been acquitted, didn't he?
He did, yes. But the reasons for the 1267 committee's decision in G's case are set out in, well, they're repeated in the statement of facts and issues in this case. Those reasons were not dependent upon the fact of his acquittal in those other proceedings. There were further matters. Inevitably, when one is dealing in matters of intelligence and dealing in matters of counter-terrorism, it's inevitable that there will be a range of material available and gathered in respect of particular persons or persons, either which may not itself be admissible in criminal proceedings, or which is of itself not conclusive to the criminal standard. Again, that premise is accepted by the resolutions to the extent that they are strong preventative measures. They are not measures designed simply to react to terrorist events. They are measures that are designed to prevent and suppress, as the turn of phrase consistently used by the Security Council.
Mr. I'm terribly puzzled about the relationship between the two different orders, the terrorist order and the Al-Qaida order. I mean, what sort of people can be dealt with under the terrorism order who couldn't be dealt with under the Al-Qaida order?
Well,
I mean, presumably IRA terrorists, I mean, people who've got nothing whatever to do with Al-Qaeda and the Taliban, is that one category?
my lord, yes, the 1267 scheme.
Sorry?
The Al-Qaeda order scheme clearly is specifically directed to Al-Qaeda and the Taliban.
I know, but that would include most, and presumably, I don't know, but does that not include the others in this case?
Well, certainly the 1373 scheme, represented by the terrorism order, is not limited to...
I know it's not, but take our case. I mean, I can't remember anybody's initials, but A, K and A.
Yes.
I mean, why couldn't they be dealt with under the Al-Qaeda order?
I'm not in a position to give you an answer to that question immediately, my lord. If I am able to give you an answer to that question, I'll take instructions if that would help. I'm afraid as these cases have proceeded on, generally on the preliminary issues, I'm afraid that the particular facts and circumstances have not been as closely.
I can't remember whether are they on the list?
No, they're not.
They're not on the list.
No, they're not. No, they're subject to the terrorism order, but not the Al-Qaeda order.
So they couldn't be dealt with under the Al-Qaeda order unless the UN decides to.
Yes, I think Lord Brown's question was, why hasn't the UN dealt with them?
They would have to be designated.
A decision would need to be taken by the 1267 committee, yes.
But one would think if there's sufficient basis for making a direction, the United Kingdom would, at the same time, put that information before the 1267 committee. And that would lead to designation.
Well, my lord, there must be within this questions of judgment. Clearly the 1267 scheme is a global scheme of sanctions. And there may be particular persons, I have no idea whether this includes A, K and M or not, but there may be particular persons where it is thought that appropriate action does not need to take place at a global level, but can take place simply within the United Kingdom, because although obviously the Al-Qaeda order only applies within the United Kingdom, the effect of designation by the 1267 committee is a global effect. And so I'm sure there will be questions of assessment from case to case.
I mean, is it right that they don't have to be designated to come under the Al-Qaeda order, do they? I thought...
Yes, they're designated by the 1267 committee, my lord, yes. They do, by the 1267 committee, yes.
By the Al-Qaeda order? I thought the Treasury could...
Yes.
Yes, but they can only... Yeah.
But only ones when 4.2.
4.2a, that would cover this lot.
But I mean, you were saying earlier today that the reasonable grounds for suspecting covers aliases, really, when you're looking at Article 4 of the
That
Al-Qaeda
was
order.
specifically... I'm sorry, my lord.
No, that's the terrorism one, sorry. No.
You've got to start with the designation. You give a directive if you consider that the particular individual is actually covered by the designation, but there's some uncertainty about it.
Yeah.
That's what he said.
But I mean, if you consider that these people are, in effect, trying to further the cause of bin Laden or one of the other designated persons, isn't that enough to come in under the Al-Qaeda order? Of course you need a direction.
On the basis they might, on the facts, fall within Article 4.2 C or D.
Yeah.
Well, I think it would very much depend on the facts of the case and whether that they were a person owned or controlled by a designated person. Again, it's not just furthering Al-Qaeda. There has to be a link there between the person you want to be the subject of the direction and the designated person. Ditto a person acting on behalf of the designated person. There are possibilities for action, but I would suggest that ordinarily, absent designation, the course of action that would probably be more straightforward and more appropriate would probably be a direction under the terrorism order. But it must depend on the circumstances of each case.
I mean, it is a position that there never has been use of Al-Qaeda order except in respect of designated persons.
May I just confirm that?
Yeah, yeah.
It's a pretty basic question. Still not complete. Never find it.
Yes, been 18
So, I mean, they couldn't be covered under the
My lord, it is possible, So far as I can get information from those sitting behind me, it is possible that in one case, a direction was made on the basis of Article 4.2d, but in all other cases, the reason why the Al-Qaeda order has applied to a particular person has been the fact of designation by the 1267 committee.
But yes, I mean, the basic point is that the 1267 committee can only designate if you're Al-Qaeda or Taliban or associated.
Yes.
Whereas the terrorism order applies to all terrorists.
Correct, my lord, yes. My lords, my lady, unless there were any further matters on which I could assist, those are my submissions.
Thank you very much. Yes, Mr. Singh.
My lords, my lady, may I reply broadly in the same structure and first address arguments under the topic of common law or constitutional rights. The first point my learned friend made was to question whether two of the rights we have relied upon are truly rights at common law, or certainly fundamental rights at common law. They were the right to property and the right to privacy. May I address each in turn? So far as property is concerned, I would respectfully invite attention to the old authority of Entick and Carrington. It's in Volume 1 at tab 2, and there is just one short passage in the famous judgment of Lord Camden, the Chief Justice of the Common Pleas, I'd like to show the Court. This, of course, was the well-known case about John Wilkes and general search warrants not being permissible at the instance of the Secretary of State. At page 1066 in the top right-hand column, 1066, Lord Camden, in the fifth line of that column, stated, "The great end for which men entered into society was to secure their property. That right is preserved sacred and incommunicable in all instances where it has not been taken away or abridged by some public law for the good of the whole." And of course, what then the court does is try to find if there is some positive law in this country which permitted the general search warrant in that case. It may be that Lord Camden had in mind the philosophical writings of John Locke nearly a century earlier, and it may be that it was thought, at least at that time, not only that property was a fundamental right in the common law, but perhaps it was the fundamental right in the common law. My lords, my lady, so far as privacy is concerned, we would accept that the leading authority on that has unfortunately not found its way yet into the bundle of authorities. But can I remind the Court of it, give the reference and undertake to supply it to the Court as soon as possible? It is the case of Smith and Grady, which is reported in 1996, Queen's Bench 517. And that case concerned, as I know my Lord Brown in particular will recall, the automatic dismissal of all homosexuals from the armed forces. And, of course, it doesn't concern rights of property or anything of that sort, but did concern very intrusive questioning by the armed forces of people's private lives, particularly their sexual lives. And when ultimately the case went to Strasbourg, of course, it was argued and indeed succeeded under Article 8, which is the right to respect for private life. So we would respectfully submit that those are rights known and protected by the common law. So far as the suggestion that my
The common law allows you to do anything that's not forbidden.
Yes, that's the classic Dycean view of liberty. But with our respect to submission, Lord, the point goes slightly further than that now, because under the principle of legality, the common law has come to recognise, by virtue of this strong presumption, not irrebuttable presumption of statutory construction, that there are certain rights which are truly to be regarded as fundamental in the common law. And around the court, Lord Hoffman said in Sims that they were not materially different from the sort of rights that one would see catalogued in, say, a Commonwealth constitution, which perhaps goes back to a point my Lord Hope made when I opened yesterday about the Privy Council forming a constitutional review role. My Lady, I wanted to turn to a slightly different point on the same topic, which a point my learned friend made was that, that he submitted that my reliance on privacy wasn't really any different materially from reliance on property. I would respectfully suggest that there is some difference. Take, for example, the intrusive requirement of reporting, which is part of the licence regime. So if you get a basic expenses licence, one of the things that you have to do, as my lords and lady know, is to report regularly as to how the money is being spent. Is it being spent on a loaf of bread at Tesco's or not? And so that's, I would suggest, an intrusion on somebody's private life which goes some way beyond simply taking their property or freezing the property. May I pick up an observation made by my Lord Mance at this juncture about the distinction between different sorts of rights? My Lord, in my respectful submission, we would say that this principle of legality recognises that some rights are to be regarded as basic or fundamental. That doesn't mean that they're absolute. Many human rights, both at common law and elsewhere, are qualified rights. May I give an example to my Lord? Sims, which is in volume 4, tab 30, concerned the right to freedom of speech at common law. And of course, that's classically a qualified right. It's not an absolute right. And finally, before I leave this topic, may I remind the Court of submissions made by Mr. Fordham yesterday. Mr. Fordham fairly put before the Court that there are two ways of looking at the principle of legality. One is to say that it bites where there is an interference with rights. I suppose it depends partly what you mean by interference. But let me make clear our position. We do say that for the reasons that Mr. Fordham submitted. But even if that submission is wrong, we rely upon the alternative fallback position suggested by Lord Hoffman in the Morgan Grenfell case and then summarised by the House of Lords in McKee. And my Lords and Lady will recall that there the formulation is one of violation. If we need it, we do fall back on that. And I say that on any view, when one looks at, for example, the right of access to an independent court and natural justice, if I have that right in the present context, then that clearly has been violated, that there just isn't any such right at all. Contrast the terms of the terrorism order, where you can go to a court under Article 5.4. Even within the Al-Qaida order, as we've just been hearing, there are some very limited circumstances where there's a designation, a direction made by the Treasury. And then again, Article 5.4 says you can go to a court under the Al-Qaida order. The one situation, importantly, where you can't ever say the Treasury is my kind of case, because I'm on the UN list and they say that's the end of the matter so far as going to a court is concerned. There we would submit that if we're right in our substantive submissions, there is a violation. And on any view, the principle of legality would therefore apply. May I turn to a discrete question? My learned friend asked the question, what is the relevant act of the Treasury which is challenged? And my lords and my lady, as I said at the outset of my submissions yesterday, Mr. Justice Collins treated this as an application for judicial review. The act challenged is the Al-Qaida order. That is an act of the executive in this country. And it is directly analogous to the act challenged in Cardi under community law. Now, the argument in the end, and I'll come back to develop this in a moment, if I may turn on this narrow but crucial difference between my learned friend and me. He submitted, as I understood him, that it was the wording of Regulation 881 which makes all the difference. I may come back to that in a moment when I address Cardi a little more in detail. But what we say about the relevance of the Al-Qaeda order is that without that act of the British executive, quite simply, the UN Security Council resolutions would be irrelevant in domestic law. They would not have any legal effect. And it's always been part of our case that let it be accepted that they are binding as a matter of international law. But that crucial difference in legal effect flows from the fundamental concept of dualism which English law takes in respect of treaty law and similar international instruments. It doesn't necessarily in relation to customary law, as I've said, but that's not relevant today. And I have to say, with respect, both to my learned friend and to anyone who would wish to rely upon the resolutions as in some way having to be complied with in domestic law, that the answer, with respect, flows from those basic authorities we looked at yesterday. Rayner, saying that it's simply irrelevant, and the CND case, in which the Divisional Court held that UN Security Council resolutions were simply not something that an English court could or should adjudicate upon.
I'm sorry, you lose me. I mean, how does this square with Al-Qaeda? I mean, unless the United Nations Security Council resolution.
Very importantly, Al-Qaeda, and I haven't come to that part of the argument. Al-Qaeda is about the European Convention on Human Rights. This part of the argument is about the common law. Your Lordship will recall that in Al-Qaeda there was a common law issue, but that was resolved on a conflicts basis, and because it was Iraqi law which governed. I suppose English law had governed. As I understand it, it would have been no defence to an action of false imprisonment under English common law to say, well, the UN Security Council requires your internment. It might have been an answer if then there had been a domestic law instrument by the British executive effectively transposing the resolution into domestic law. But unless there's been such an effective transposition, the Security Council resolution is binding at the international law level, but is simply irrelevant at the domestic law level. And that's a situation that can arise in many spheres of life.
It's slightly circular, this argument, isn't it? Because the whole point of Section 1, subsection 1, is to enable the transposition into domestic law of...
That's the real issue. That's the real issue between us. But the fact that it's binding, let it be assumed it's binding, international law, it's quite simply irrelevant. And that's why, and I deal with this under the topic of what is the act in question. The act in question is whether the Al-Qaeda order is ultra vires or intra vires. And that, my Lord, is right. It comes back to construction of Section 1 of the 1946 Act. To answer that question, the courts have, over the years, devised various presumptions and principles of statutory construction, one of which, a powerful one, although not really rebuttable, is the principle of legality. We say it helps this court to answer that question. Can I turn to a different authority that my learned friend...
Are you coming back to Regulation 881?
Yes, we are.
You are.
My Lord, yes. May I deal with that in a moment in the context of Cardi? Bayrami was referred to. I'll just give the reference, if I may. It's volume 16, tab 131. And I simply make the observation that it really doesn't assist this court in answering the problem it is faced with, because the legal issue in that case for the Court of Human Rights was the issue of attribution. In other words, which person's act is it? Is it the relevant contracting state or states under the ECHR, or is it an international organisation? In that case, it was held to be an act of the United Nations. The question, in my respectful submission, ultimately always comes down to, in a sense, which end of the telescope one looks at it from, or in a sense that one could ask the question, on whose watch is the question arising, is the legal question arising? There are at least 4 different courts that may have to deal with questions in the same sphere. At the international level, there is the International Court of Justice. At the European level, there is in the EU, the Court of Justice, and in the Council of Europe, the Court of Human Rights. And in this country, so far as the common law argument is concerned, there are the ordinary courts of this country. And as I submitted yesterday, the answer may indeed differ, because inherently these different courts are applying the legal systems of which they are a part and whose rules they have to implement. And as the ECJ readily acknowledged in Cardi, that implies nothing improper or disrespectful of the UN. They said explicitly that it was simply no part of their role to review the validity of the Security Council resolutions, but it was their role to give effect to community law rights, including rights of natural justice and effective judicial protection. And that's all I ask for in the common law system. My lords and my lady, can I briefly deal with a topic that was referred to about various attempts that have been made during the passage of the last few years at the UN level to improve fairness. Now, our basic position is, in a sense, encapsulated in an observation made by my Lord Brown to Mr. Swift, that the government submission is and has to be, it doesn't matter whether there's unfairness at the UN level, it's a binding obligation. It has been effectively transposed using the enabling power in Section 1. We say, not so. But just looking for a moment at what fairness there is, true it is that there have been attempts to improve fairness at that level, but still nothing close to what we or the ECJ would recognise as basic fairness. What the open material that can be disclosed to the individual and their representatives is what can be found on the website. In other words, it's material which is regarded as sufficiently anodyne that it can safely be broadcast to the world. There is still no system for any kind of judicial body to make any kind of order in relation to these executive decisions. And as the Advocate General observed in Cardi, there is no duty even to take into account the representations that may be made by the individual to the committee indirectly. Perhaps it's stating the obvious, but it's emphatically fundamental to our case. There is no court, on the Treasury's argument, there is no court that can make an order quashing the draconian effects placed upon my client by transposition of the resolutions, even if somehow any court could assess the evidence for itself and concluded decisively that my client is not a terrorist associated with Al-Qaida or anything of that sort. That's the fundamental deficiency in effective judicial protection that there is in this regime. My lords and ladies, may I now turn to Regulation 881 and Cardi, which concerned that regulation. The regulation itself can be found in Volume 19 at tab 180. Volume 19 at tab 180. And we see the legislative technique used by the Council in this instance in Article 2. The relevant persons are identified in this way. There are two, as a matter of form and wording, I accept. There are two conditions. One is that the person is designated by the Sanctions Committee, and the other is that they are listed in Annex 1 to this regulation. And it may be that ultimately, when all is said and done, the fundamental dispute between Mr. Swift and me on the common law issue comes down to this, that he says that makes all the difference. He says, as I understand it, that if the qualifying condition for the regulation to apply had been simply the first condition, designated by the Sanctions Committee, without a further list, without those people being listed in Annex 1, so if the wording had just stopped after the word Sanctions Committee, he says that would be materially the same as Article 3.1b of the Al-Qaida order. And therefore, as I understood his argument, he suggests that Cardi would have been decided differently, and that's how this court should decide the present case, because he says there is no relevant decision at all by the UK executive. Now, in my respectful submission, that is truly to allow form to triumph over substance, which is the wrong approach, in particular in a context which deals with fundamental human rights. Just to test whether that argument can possibly be right, suppose one takes an example that my Lord Mance put, I think, earlier this week at this hearing. Suppose the Al-Qaida order, the UK order, had not confined itself, and the resolutions had not confined themselves to a requirement by the UN that member states should freeze a person's assets, but had gone slightly further and said, freeze the person as well. What my Lord, I think, referred to as indefinite detention without trial. Just to test the argument, as I understand him, my learned friend would then submit that because the Al-Qaida order is drafted as it is, that all the submissions he has made to this court would still be the same, that there is no relevant act of the UK executive. There is nothing to be challenged in a court. If you went, presumably, if you did try to sue your jailer, the physical detainor, by using the tort of false imprisonment, you would, on his submission, presumably have the defence as the jailer that there was lawful authority. The lawful authority would be the Al-Qaida order, and if anyone sought either directly or indirectly to challenge the vires of that, he would say again, Section 1 of the UN Act has authorised it. Now, Lords and my Lady, I have to say that that's either right or it's wrong. We respectfully submit that it is fundamentally wrong. Parliament has sanctioned no such thing. And if Parliament were to, that's not this case. There might be questions that would then arise under the Human Rights Act or in other ways, but that is not this case. Parliament has not authorised the executive to do any such thing in Section 1 of the UN Act. If that's right in that context, in my respectful submission, it's right also in our context, because analytically, the arguments for both sides are the same. And in my respectful submission, the analogical force of the ECJ's reasoning in Cardi is equally applicable in both contexts.
I don't think it really mattered, as far as the reasoning of the ECJ is concerned, whether or not the Article 2 had been framed in the way we find it, or just simply said that all funds held by a group or person designated shall be frozen, because either way it would be a community measure.
Yes.
And as I understand the reasoning, that would then
Yes.
open it up to scrutiny in accordance
Lord,
with the
indeed.
principle to describe. The distinguishing feature,
Yes.
of course, is that the European Union is not a party to the Charter. Isn't that the point?
Well, Lord, of course, that's factually correct so far as it goes, but in my respectful submission, the fact that the UK is a party to the Charter, while true, is legally irrelevant for reasons I've already developed earlier, that our system of dualism means that a UN Charter obligation cannot alter the citizens' common law rights in our constitutional arrangements unless Parliament has sanctioned that. And of course I accept that to some extent the argument for both sides is then circular, because the Treasury says we have got that parliamentary sanction, we say they haven't. I don't want to rehearse that argument.
They didn't mention Article 307 of the European Communities Treaty, did they? Which is the article which says that rights and obligations arising from international agreements concluded before the European treaties remain binding.
No, Lord, I think that's right, from my recollection.
I mean, that's one of the points that Professor Tridimas makes, that it's
that
a
is
bit
right.
odd, because that's direct lead into Article 103, one would have thought.
Well, that's right. But can I deal with that now, if I may, because I was going to, if I may, respond to a point that my Lord Roger put to my learned friend also, on whether it's the timing of relevant treaty obligations which makes all the difference. In my respectful submission, that should not affect the legal analysis. As I understood it, the argument, I'm preempting myself slightly, but I hope I'll be forgiven, the argument arose directly in the context of the ECHR and the relationship between the ECHR and the UN Charter, Article 103. There's the Al-Jeddah case, of course, that I have to face. In that context, my lords and my lady, I make this submission in reply, that it cannot matter ultimately as a matter of law when exactly a state entered into a treaty arrangement, because there can often be apparently conflicting treaty obligations, sometimes stark ones. Take classically the Chahal or Suring problem, where you will have often an extradition treaty which apparently conflicts with a human rights obligation. Suppose in a case like Chahal or Suring, the relevant extradition treaty had been entered into before the UK became a contracting party to the ECHR. In my respectful submission, that would not affect the analysis. In human rights law terms, again, asking which end of the telescope do you approach it from, the ECHR would still approach it from the Bosphorus point of view.
Supposing that there's an absolute obligation in terms of Article 103, let's just suppose that as of 1945.
Yes.
I mean, nobody renegotiates the Charter. It's still the same Charter. A group of nations agree the Convention. Now, does that change the obligations which they have under the Charter?
No. Well, it doesn't change anything under either instrument. The obligations in each instrument have to be construed to see what their true meaning and effect is, approaching it at one level from the point of view of international law, another level approaching it from the point of view of the jurisdiction of the ECHR, and so on. And there can be, let it be accepted, there can sometimes be conflicts, but it depends on which... I'm sorry.
When you enter into the Convention,
yes.
You know that you are bound by the Charter, and the
yes.
Charter says that the obligations under it prevail, if in doubt.
Well, with respect, there's a slight danger of bootstraps problem there, because of course the Article 103 is a provision in that treaty. There's not a provision in the ECHR, for example. So you may well have undertaken different legal obligations potentially. Somehow they have
compatible obligations.
Well, my lord, somehow harmony has to be achieved.
Yes. And you know when you enter into it, if you get any doubt, you're already bound by the Charter.
Well, just for the sake of argument, suppose the UN Charter, it doesn't say this, I know, but just to test the proposition, suppose it said that member states shall retain the death penalty. And then later on, in time, as social standards and policies in European democracies have evolved in the last 50 years, they agree, as they have agreed, the 13th Protocol. In my respectful submission, so far as the ECHR court is concerned, and therefore the courts of this country, so far as they're applying the Human Rights Act, they have to apply the norms under the Human Rights Treaty. And of course, I recognised yesterday, my Lord, that this is a difficult problem. There are potential conflicts. One way that the Court of Human Rights itself has suggested for trying to achieve legal harmony is the Bosphorus solution, which is, and I think, I'm not familiar with Germany, but my Lord suggested that the German Constitutional Court has a similar approach, which is you try to ask, obviously you respect international institutions so far as you can, but there may come a point when you have to say, no, sorry, this is so inconsistent with the terms of our basic legal order that we cannot give effect to it on our watch, however binding it may be. If somebody did take a case in The Hague, the answer might be different. It might not be, as my Lord has observed. The Hague might try to achieve legal harmony as well, given the purposes of the UN. But my basic submission is that it doesn't matter. If you couldn't achieve that legal harmony at the international level, it matters not, because the justiciable rights...
Have we not already given away our sovereignty in 1945 to the...
Well, Lord, I don't want...
On that matter?
Lord, I don't... No.
To the UN?
I don't accept that, my Lord. I don't want to repeat what Mr. Owen in particular has submitted at length in his appeal. Suffice to say that neither of us would respectfully accept that in enacting Section 1 of the UN Act, Parliament was giving away that kind of wholesale...
No, I wasn't meaning that. I was talking internationally to the United Nations.
Well, with respect, I'm not sure I understand what sovereignty in that context then means. It is true that we have undertaken obligations, yes, and there can sometimes be incompatible legal obligations. You try, so far as possible, to achieve harmony. If you can't, then I come back to my basic principle. The answer depends on which court you are, of what legal system are you a member, and therefore which legal rules do you have to apply. And dualism actually provides a very large part of the answer. I don't mean any disrespect if I say the boot has often been on the other foot. People have often tried to invoke unincorporated international human rights treaties and given short shrift historically.
Very familiar argument.
Yeah. Lords, my lady, I don't know if I've said enough about Cardi in reply. If there are any other questions on that.
I think you probably have.
I'm grateful.
What about, you're not going to say anything more about Mr. Fordham's?
Yes. Can I just briefly deal with that? Well, Lord, we've made our submissions. As my Lord knows, we've made them. I've said that I don't need that argument. I win well before, whenever it reaches that stage. That's not to say that it's a bad argument. Mr. Fordham's raised it for the court's consideration, but I think he also would agree with me that it's not necessary. If it's not necessary to the determination of this dispute, then we would respectfully suggest that the conditions for reference wouldn't arise, even if the point is not that clear.
So that's this Fordham's argument based on paragraph 30 of the Advocate General.
Exactly, exactly, my Lord, yes. And my Lords and my Lady, can I briefly turn to the procedural points? So I hope I've addressed adequately in reply the common law argument, the human rights and Al-Jeddah argument, and now I turn briefly to the procedural points in this case. The basic point that we would wish to make is that this is a claim for judicial review, but that, of course, is of the Al-Qaida order. That claim for judicial review, unless the Court of Appeal is right, on both sides' arguments in this court, actually doesn't give us any opportunity to go before an independent court to ask that court to look for itself at the evidence which is said to justify labelling my client an Al-Qaeda terrorist. Now, it's not impossible to have such a system. There are systems of such judicial review, call it merits-based review if one likes. But they are what the ECJ would call effective judicial protection. Take, for example, the control order regime. That allows you to go before a court to have the evidence tested independently. Take even the terrorism order itself, where there is a direction by the Treasury. That's how it works. Take even the Al-Qaeda order itself, where there is a direction by the Treasury. Not my case, I know, but it's not as if the sky would fall in if you have to have some kind of merits-based review by an independent court. That is effective judicial protection. The one instance where we don't have that at all is where I am on the UN list. Mr. Swift says, well, that is it. That's the case against you. Not why they've said you're an Al-Qaeda terrorist. And it's still more unnerving, if I can use Lord Justice Sedley's words, because I do remind the court that it was the British state that put that suggestion to the Sanctions Committee. So my client has been put on this list effectively at the behest of the British state. And then the British state says there is no court in this country, indeed there isn't a court anywhere in the world, that can look at the underlying evidence, if necessary in closed session, if necessary with a special advocate, if necessary with dispensation of the intercept warrant restriction. Mr. Swift says, simply, there's nothing for a court to adjudicate upon, save possibly, I suppose, to ask the question, are you this person? And in my respectful submission, that cannot be the state of our law. It's not only unfair, it is unlawful, and that's what renders the Al-Qaeda order, in this case, ultra vires. My lords, my lady, unless I can assist further, that's my reply.
Thank you very much.
My Lord, my Lady, again, I would like to adopt Mr. Ravinder Singh's submissions. I'm going to be very quick and make two very short points. I won't go into the procedural archaeology that is already set out in the printed case, perhaps too fully, on questions such as Mr. Justice Owen's state of knowledge and our state of knowledge as to special advocate procedures, and the basis upon which the FCO had concluded their views. I don't want to take time about that. We make the point that it is now, we now know that the FCO's position is on the basis of the material that was seen by the 1267 committee. My Lords, on the question of whether the adjustments that the Treasury have made are minor or not, again, I'm going to be very quick and simply give you references if you'd like them. The relevant letter from the Treasury is at 475 in the bundle, and the position is set out at paragraph 13 of our printed case. The position is that that Hay's family is still only entitled to expend funds on basic expenses. The transfer of funds was permitted in order to allow school fees to be paid. That was in response to a request that was made on the 16th of June, that is to say, before Mr. Justice Owen's order on the 10th of July. Hay is not allowed access to any cash whatsoever, only his wife is. And you have that at page 128, para 10 in the bundle. The reason why this is perhaps important is because of my next and final point, which raises issues of more significance, we respectfully suggest. And this is on the cross-appeal. Mr. Swift said, and we took a careful note of it, that Mr. Justice Owen was entitled to make the declaration that he did because he was entitled to take into account how the Treasury would consider, and these are the critical words, the way in which the Al-Qaeda order was to be applied pending the decision of the 1267 committee. So not pending the appeal to this court. And the inference is that even if this court repeats the order that Mr. Justice Owen made and declares the Al-Qaeda order unlawful in its application to Hay, then the Treasury would again consider, to use Mr. Swift's words, the way in which the Al-Qaeda order would be applied pending the decision of the 1267 committee. And we respectfully submit this is nothing less than subversive of the normal relationship between the executive and the courts. I have in mind the acceptance by Mr. Richards, as he then was, before the House of Lords in the M case, that the executive was and considered itself duty-bound to obey the law as declared by the courts, so that there was no need for a coercive jurisdiction or a contempt jurisdiction. And we'd respectfully end our submissions by saying to avoid any such possibility if the court is with us on the issues of substance, and the appropriate order would indeed be to make a quashing order rather than a declaration which, for whatever reason, may not be implemented subject to what the committee in New York decide. Those are my submissions.
Thank you. We shall reserve our judgment.